Imagine picking up your toddler from daycare and realizing he hasn't eaten anything in nearly 6 hours. No snack, no lunch, nothing. And when you ask the people responsible for your child's care what happened, their answer is, maybe someone forgot to document it. That's not a clerical error. That's a red flag the size of a billboard. And for one Indiana mother, it was the moment she realized her instincts had been right all along. Welcome back to the channel. Today we're diving into a story that every parent needs to hear, because what happened to this family could happen to yours. We're talking about neglect, cover-ups, and what your legal options actually look like when a daycare fails your child. Stay with me because this one gets serious fast. Let's set the scene. A mother in Indiana decides to enroll her 21-month-old son in daycare 1 day per week. Just 1 day. The reason is completely reasonable. She's attending school full-time over the summer and wants her son to slowly get comfortable with the daycare environment before she's relying on it more heavily. This isn't a family throwing their kid into full-time care without a second thought. This is a thoughtful parent making a gradual transition to protect her child's emotional well-being. She's doing everything right. The daycare uses an app called ProCare, which is a childcare management platform that allows parents to track what's happening with their kids throughout the day. Meals, naps, activities, that kind of thing. It's supposed to give parents peace of mind and transparency. In theory, it's a great tool. In practice, for this family, it became the key piece of evidence that something was very wrong. Now here's an important detail about the stakes. A 21-month-old child cannot advocate for himself. He cannot walk up to a staff member and say, "Excuse me, I'm hungry and it's been 4 hours since I last ate." He cannot call his mother. He cannot tell another adult what's happening. He is entirely dependent on the adults in that room to notice his needs, respond to them, and document them. When that system breaks down, the consequences for a child that age can range from misery and distress to genuine physical harm, including low blood sugar, dehydration, and developmental impacts from chronic stress. This is not a small matter. This is a child's basic welfare. So let's walk through exactly what happened and how this mother uncovered the truth. Her son starts attending this daycare once a week. The first visit goes by, then the second. By the second and third visits, she starts noticing something when she picks him up around 4:30 to 5 in the afternoon. He is absolutely starving. We're not talking about a kid who wants a snack because he's used to snacking at home. We're talking about the kind of hunger that tells a parent something is off. Any parent who has watched their toddler eat knows what normal hunger looks like versus something more urgent. This felt urgent. Now here's where the story adds another layer of concern. This mother had been trying for 3 full weeks to get access to the ProCare app. 3 weeks. She had also been trying to get the door code for the facility. Neither had been provided to her. Think about that for a moment. She enrolled her son, she's paying for this service, and for 3 weeks she cannot get into the building independently or check on her child's daily activities through the app they specifically use for parent communication. That is not acceptable under any circumstances. But it becomes much more suspicious when you find out what she discovers the moment she finally gets access. After complaining about the lack of access, she is finally given both the door code and the ProCare app login. The very first day she checks the app, she goes back through her son's records for those 2 days when she noticed he came home starving. And what does she find? No documentation of her son receiving any food after 11 in the morning, on either day. For a child who isn't being picked up until 4:30 or 5 in the afternoon, that is a gap of 5 to 6 hours with no recorded feeding. And we know from the staff themselves that their policy is to document everything, including when a child refuses food. So the absence of documentation is not an explanation, it is evidence. She does the right thing. She reaches out to the daycare and asks a very direct, very reasonable question. She explains that she now understands their documentation policy. Everything gets recorded, even refusals. So she wants to know why there is no evidence of her son eating anything for approximately 5 hours on 2 separate days. And the response she gets back is stunning in its casualness. The answer, essentially, is maybe someone forgot to document it. Let's sit with that for a second. The staff had just confirmed to this mother that everything is always documented. Every meal, every refusal, every snack, that's the policy. And now when confronted with evidence that directly contradicts that assurance in a way that suggests a toddler may have gone unfed for the better part of a day, twice, the explanation is a shrug and maybe someone forgot. That response tells you everything you need to know about how that facility operates and how much accountability exists there. But it gets worse. Remember the door code issue from earlier? When this mother had originally complained that she didn't have the door code, the owner of the daycare told her that she had already given the code to her husband. Except, her husband was sitting right there beside her when this happened. He heard it in real time and stepped in to make it clear that he had never received any door code. The owner had lied, not made an honest mistake, not misremembered, lied directly and confidently in the face of someone who could immediately contradict her. That moment is critical because it reframes everything else. When a business owner lies to a parent about something as simple and verifiable as whether a door code was shared, it tells you that dishonesty is a default response to accountability there. It means that when the staff says maybe someone forgot to document, that might not be an honest admission of error. It might be the safest lie they could reach for in that moment. This mother made the decision to withdraw her son from the daycare immediately. She no longer trusted the quality of care, and frankly, she had every reason to distrust it. But her question, and the question we're going to answer for you today, is what can actually be done? Is this just a situation where you walk away and warn your friends, or are there real steps you can take? The answer is yes, there are concrete steps, and here's what they look like. The first and most important step is to file a complaint with your state's child care licensing agency. In Indiana, that is the Division of Early Childhood within the Indiana Family and Social Services Administration. Licensed daycares in Indiana are required to meet specific standards around nutrition, supervision, and record keeping. What this family experienced, undocumented feeding gaps, restricted parental access, and documented dishonesty from staff, are all potentially reportable violations. You don't need a lawyer to file this complaint. You go to the FSSA website, find the Child Care Licensing Complaint Form, and document everything you experienced with dates, screenshots, and any written communications you have from the facility. The second step is to document everything before memories fade and evidence disappears. Print or screenshot every entry from that app. Save every text message or email exchange with the facility. Write down the date and content of every verbal conversation, especially the one where the owner lied about the door code while your spouse was present. The more organized and detailed your documentation, the more seriously investigators will take your complaint. Third, consider reporting to Child Protective Services as well. Some parents hesitate to do this because they worry it sounds extreme, but CPS reports about child care facilities are not just for situations that have already caused visible harm. They are also appropriate when there is credible evidence of neglect. And failing to feed a toddler for 5 or 6 hours, then lying about it, meets that threshold. Fourth, if other families use this daycare, you have an ethical obligation to warn them. You don't need to make accusations you can't prove. You can simply share your documented experience and let other parents make their own informed decisions. Leave a factual review on Google or Yelp. Post in local parenting groups. Let the evidence speak for itself. And fifth, consult with a family law or personal injury attorney if your child experienced any measurable harm. An initial consultation is often free, and an attorney can advise you whether there is a civil claim worth pursuing, particularly if there are medical records or other evidence of impact on your child. Here's the bigger lesson in all of this. When a child care provider limits your access to documentation, restricts your ability to enter the facility, or responds to legitimate concerns with dishonesty, they are not protecting your child. They are protecting themselves. A trustworthy daycare welcomes your questions. It gives you app access on day one. It never lies to your face with your spouse sitting right next to you. Your parental instincts exist for a reason. If something feels wrong, it very often is. If this has happened to you, If your child has come home from daycare showing signs of neglect, if you've been stonewalled when asking for basic information, or if you've caught a facility lying to cover up a mistake, don't let it go. Report it, document it. Protect not just your own child, but every other child in that building who doesn't have a parent fighting for them yet. If you found this video helpful, please subscribe and hit the notification bell so you never miss an episode. We cover real legal situations that affect real families, and we're here every week to help you understand your rights and what you can actually do about it. See you next time.